Well, the EPA has issued a new Waters of the U.S. rule, despite the fact the Supreme Court has not yet weighed in on a case that it's been hearing and heard last spring. And ag groups are already expressing concern. The new rule takes farms on a case-by-case basis when it comes to small, isolated, and even temporary water features. NCBA says it couldn't come at a worse time, saying the Supreme Court still hasn't issued a decision in the Sackett case. And that case should bring final clarity to the Clean Water Act. NBCA says today's decision seeks to preempt ongoing litigation and creates even more confusion for farmers and ranchers. The National Association of Wheat Growers expressed similar concerns. Roger McEowen with the Washburn School of Law joins us now for more on this and other factors. And listen, Roger, I know you haven't had a time to really look over this definition of what they came out with today, but there is a lot of confusion, especially for producers, being that the Sackett case has not been yet determined. And I know a lot of people waiting on that. I'd like to get your thoughts.
No, I haven't had time to pound through 514 pages of a new rule. This is just, it is bad timing, and it's kind of meaningless until the U.S. Supreme Court tells us what the rule is going to be. I mean, the agencies can do whatever they want to do in this instance, but it's meaningless until the Supreme Court tells us what the rule is. And then the agency's going to have to go back probably and rewrite the rule again. I would be concerned about what it says about prior converted cropland. That is a longstanding exemption that farmers have had. This one appears to pare that back, and that's going to be problematic. So if they try to enforce this rule between now and when the Sackett opinion comes out with hopefully a clearer definition of a wetland, we're going to have a mess.
Hey, another big ag law development that we wanted to cover, and the reason for us talking to you today, the 2022 that centers a boundary dispute. And I'd like you to talk about that case.
You know, boundary disputes in agriculture, outside of questions I get beyond the tax realm, leases and property boundaries and fences are probably consume more of my time than anything else. There were a couple of cases recently, and these are state level cases, one from Missouri and one from Ohio, that involve the concept of adverse possession and when that applies. And the Missouri case involved somebody that bought a rural property and had an existing fence on it. They had used it for over 20 years, almost a quarter of a century, thinking that they owned the property up to the fence line. Well, the new owner buys the tract adjacent to him, has it surveyed. That survey says, no, the real line is 40 feet over onto your neighbor. And so he now got a dispute about this disputed strip. The point I want to get across to people is, and people who move out from towns and cities to rural areas commonly do not understand this. Your survey doesn't really mean a whole lot. How that boundary has been utilized is what's the key. And that's what the Missouri Court of Appeals said in this case. Is, look, this party's been using that particular fence as the line for a long period of time. And that's defined by state law in a particular way. And they've used it as their own in an open fashion. It doesn't matter really what your survey says in that instance. We're not going to change the boundary because you've got a survey that says the line is somewhere else after many years of usage in a certain fashion.
So what's contributed to the court's ruling? Is it because of all the time that had went by and that's how it was being used?
That's part of it, but largely it was on credibility of witnesses, too. I mean, they had a surveyor, and their surveyor said that, no, it's the fence line, and that was deemed to be more credible as a witness. Plus, the other people, they go back generations, and they could get testimony as to how that property line had been used and where the boundary was treated as by prior owners that they could tack their ownership interest onto. So, and that's typically how it happens in rural areas.
Very interesting stuff, as always. Roger, thank you so much. Happy New Year to you. Enjoy your weekend. Roger McEowen with the Washburn School of Law. Always appreciate him joining us.